The Maryland Department of Health, Developmental Disabilities Administration, Self-Directed Services Training Series, Module 17, Labor Laws, updated October 2024. This training module will provide you with an overview of labor laws associated with the Maryland Department of Health, Developmental Disability Administration, DDA-operated Medicaid waiver programs. This training is a summary with important information on this topic. More information and requirements are found in the Medicaid waiver program applications, laws, regulations, guidance, and policies. The most updated information regarding self-directed services is published in the Self-Directed Services Policy and Manual that can be found on the DDA's website. The participant who self-directs their services is the employer of record, subject to all federal, state, and local laws associated with being an employer. As the employer, they are responsible for keeping track of all changes in employer law. This training is an introduction to the types of laws participants are responsible for. This module is not intended to be legal advice. Please consult with the participant, their team, and/or an attorney for support in understanding the law. The DDA will not train participants, support brokers, or other team members on ways to interpret laws. In this training, we will review some types of labor laws that may affect participants who self-direct their services. Those laws are related to fair employment practices, wages earned, overtime, leave, and record keeping. Federal, state, and local laws exist to make sure employers do not discriminate against any employee or potential employee. Laws associated with discrimination against employees or potential employees include unfair treatment due to a protected class, harassment by managers, coworkers, and others, denial of the reasonable workplace accommodations due to a disability, and retaliation because of complaints and discrimination. This slide includes examples of laws enforced by the U.S. Equal Employment Opportunity Commission. It is important to note that all of these laws make it illegal to retaliate against a person because the person complained about discrimination, filed a charge of discrimination, or participated in an employment discrimination investigation or lawsuit. Title VII of the Civil Rights Act of 1964 makes it illegal to discriminate against someone on the basis of race, color, religion, national origin, or sex. The law also requires that employers reasonably accommodate applicants and employees' sincerely held religious practices, unless doing so would impose an undue hardship on the operation of the employer's business. The Pregnancy Discrimination Act amended Title VII to make it illegal to discriminate against a woman because of pregnancy, childbirth, or a medical condition related to pregnancy or childbirth. The Equal Pay Act of 1963 makes it illegal to pay different wages to men and women if they perform equal work in the same workplace. The Age Discrimination in Employment Act of 1967 protects people who are 40 years or older from discrimination because of age. Title I of the Americans with Disability Act of 1990 makes it illegal to discriminate against a qualified person with a disability in the private sector and in state and local governments. The law also requires that employers reasonably accommodate the known physical or mental limitations of an otherwise qualified individual with a disability who is an applicant or employee, unless doing so would impose an undue hardship on the operation of the employer's business. The Genetic Information Non-Discrimination Act of 2008 makes it illegal to discriminate against employees or applicants because of genetic information. Genetic information includes information about an individual's genetic test and the genetic test of an individual's family members, as well as information about any disease or disorder or condition of an individual's family members. For example, an individual's family medical history. The Pregnant Workers Fairness Act of 2022 requires that a covered entity provide a reasonable accommodation to a qualified worker's known limitation related to pregnancy, childbirth, or related medical conditions, absent undue hardship. State Government Article Title 20, Subtitle 6, Annotated Code of Maryland, notes that every Marylander is guaranteed equal opportunity in receiving employment and in all labor management unions, relations regardless of sex, regardless of race, color, religion, ancestry or national origin, sex, age, marital status, sexual orientation, gender identity, disability, or genetic information. This means that employers cannot discriminate in recruiting, interviewing, hiring, upgrading, setting work conditions, or discharging. Labor organizations cannot deny membership to qualified persons or discriminate in apprenticeship programs. Employment agencies cannot discriminate in job referrals, ask discriminatory pre-employment questions, or circulate information that unlawfully limits employment. Newspapers and other media cannot publish job advertisements that discriminate. Harassments on the basis of a protected class, such as sexual harassment and retaliation for filing a complaint or being involved in the investigation, are both prohibited under the law and enforced by the Maryland Commission on Civil Rights. Slide relates to required minimum wage requirements. There are exceptions to each of these minimum wages, but these rates listed are generally true. Many states and local governments also have minimum wage laws. In cases where an employee is subject to one or more minimum wage law, the employee is entitled to the higher of the minimum wages. Overtime. The federal overtime provisions are contained in the Fair Labor Standards Act. Unless exempt, employees covered by the Act must receive overtime pay for hours worked over 40 in a work week at a rate not less than time and one-half their regular rates of pay. There is no limit in the Act on the number of hours employees aged 16 and older may work in a work week. The Fair Labor Standards Act does not require overtime pay for work on Saturdays, Sundays, holidays, or regular days of rest, unless overtime is worked on such days. The Maryland Healthy Working Families Act, often referred to as Sick and Safe Leave, took effect February 11, 2018. The Maryland Healthy Working Families Act requires all employers with employees whose primary work location is in Maryland to provide earned sick and safe leave, regardless of where the employer is located. Employers who employ 15 or more employees are required to provide paid earned sick and safe leave. Employers with less than 15 employees are required to provide unpaid earned sick and safe leave. Leave accrues at the rate of 1 hour for every 30 hours that an employee works. An employee is not entitled to accrue sick and safe leave during 1. A 2-week pay period in which the employee worked fewer than 24 hours. 2. A 1-week pay period if the employee worked fewer than a combined total of 24 hours in the current and immediately preceding pay period. Or 3. a pay period in which the employee is paid twice per month and worked fewer than 26 hours in the pay period. The leave hours provided for under the law are the minimum number of hours an employee is entitled to earn and accrue. An employer may provide more leave for its employees. Maryland law requires employer records to be kept for each employee with their name, address, race, gender, and occupation, and their rate of pay for each employee, the amount paid each pay period for each employee, and hours that each employee works each day and work week. Medicaid requires records to be kept for 6 years. This and the next 2 slides include useful resources. Summary. Participants who self-direct are subject to all employer law, including those laws related to fair employment practices, wages including minimum wage, overtime, leave, unpaid and paid, and record keeping. Participants are responsible for following any changes made to federal, state, or local employment laws. This ends Module 17.